Kelvin Biles here again from Jackson District Library. Today we have Mark Stanley from Southeastern Dispute Resolution, and he is going to talk about eviction and diversion. So if I'm got the letter to be notified that I'm being evicted, who should I contact? Should I go to the court, then go to you, and they lead me to you? Do I go directly to you or legal services? What do I do?
Yeah, good question. After a landlord files either, an eviction or a possession order or something, you're going to get a packet from the court with a hearing date, a pretrial that's going to have the Zoom information for our office, and it's going to have like a flyer and some contact information and an overview of what the eviction diversion process is. So it's going to tell you where the money is coming from and tell you what county it's for. So essentially, the first contact that we want everybody to make is call Community Action Agency, talk to a housing specialist. You can start your application process right away and get your eligibility determination right away, even before you come to your hearing. And that's typically the best thing to do, is if you do that, CAA can contact your landlord before the pretrial. And if you get a settlement, you don't have to come to us. You could just work it out as long as there's a filing, and it doesn't even have to be a court filing. If your landlord says, I'm going to evict you, it gives you a note to that effect. You can go to CAA and work out a settlement without having any court filing. But essentially, the way we have it set up is we're getting our cases 2 to 3 weeks in advance. And that way, CAA and their staff can contact the tenants and landlords to see if they can work things out before they get to us. And if they do, then the court will just add cases on for that week. If it's early enough in the process, you may not even need to come to the pretrial or have a hearing. So that would be their first step, is talk to CAA, talk and see what's available. I mean, currently, since there aren't any funds available, we're funneling everybody to CAA, and then they're talking to the Department of Health and Human Services and talking about emergency services grant money, ESG funds.
Yep.
And that's typically what would have happened in past.
With that, when we didn't have all the COVID funds.
Yes. So They would have went to DHS, filed an SER to see if they're eligible for state dollars through the Department of Health and Human Services. And then if they're given a denial, then you try to work something else out. But usually that's the way landlords would have got paid. But now you just go directly to Community Action Agency, and then you can educate the landlord and their representation about the process and what your tenant's eligible for, and work out a payment. Otherwise, you come through the pretrial and you do it with us. And then your second call would be to contact legal services to get a consult before your pretrial, or you can just wait until you come to us and you get access to an attorney at that point.
And when you say when you come to us, you mean like the day of the pretrial hearing?
When you come to the pretrial, you're coming to us. Yeah.
So say I get assistance. Does the money come directly to me as the tenant, or does it go directly to the landlord?
No, it goes directly to the landlord. So that's a direct payment from the housing authority, in our case, Community Action Agency, to the landlord.
And the tenant, does he or she get some sort of proof? What do they have? So just in case the landlord wants to come back and be like, you didn't pay me.
All the payment paperwork would go to both parties. There'd be receipts and documentation for both sides. At the pretrial level, either we have the written dismissal or the partial agreement that the court would have in your case file, and all that gets sent to you as well.